Are you Mr. Ash that's in the Zoom booth?
Yes.
All right, very good. And I see you there, Miss Ash. So this is on for review. We were last here. Back in June of this summer. At that point, we were looking at reviewing this matter in adequate cause. I see that there was a urinalysis or UA that was filed. And the court was also looking for potentially a evaluation from CORE. So, sir, what's your status on that?
I have all that paperwork still. I have not got it single copied to turn in. I gave Miss Ash a copy of my records. I know the last time we met, we were waiting on for me to get a anger management evaluation scheduled. I have one set for September 15th. At 2:00. That's the earliest she could get me in as to do. She's the only one that does them, I guess. And that's kind of where I'm at with that. I have that all paid for and ready to go. So I kind of figured that's when I came in today that we would come back after I had that done on the 15th. That's the earliest I could get one scheduled.
Okay. That seems reasonable. I understand that it can take time to get those things scheduled and get them available for this kind of the reality of being able to get those things done and completed. All right. Anything? So sounds like he's asking for essentially a continuance. And so, ma'am, I'll turn the time to you. What input would you like to give the court?
So from the paperwork that he had delivered at my apartment building, it looks like he had a drug assessment at CORE over a year ago with Mike Sovol, and Mike's letter states that he had an assessment, had amphetamine addiction severe, and was recommended that he did treatment. He did not return for treatment.
Okay.
So
I understand that. But also where we are is I have a UA before the court that shows no usage. So here's what I'm going to do. Number one, I appreciate that you provided Ms. Ash with a copy of those records. What I don't have is a copy of those records. And so you can both talk about them, but at the same time, I can't read them obviously because nobody's filed it. So I'd ask that one or both of you file the documentation that you have so that the court can have a copy. And that way I can read it and see what was done and what wasn't done. So
okay.
if you're the one who wants to move forward, I certainly suggest you file it. Ma'am, you certainly also want to talk about it, so I suggest you file it as well. Go ahead.
Can I ask one more question?
Go ahead.
Okay. So since this is something that he's needing to do, like how much of a continuance does he need? Because I have to take multiple hours of sick time. I'm not allowed to just take 1 hour every time we have one of these appointments. And if he's not going to be prepared, he's taking that time that I could be using for something actually important, like an actual sick appointment.
I'll get to sort of when we're going to continue it at the end. So okay. I appreciate that commentary though. Okay. So we're looking for that drug assessment to be filed. Additionally, it sounds like the anger management evaluation is being done it's almost the next month, mid-September. Sometimes those reports are pretty quick after the appointment. Usually you'll get the report within a week or so at a minimum after that appointment to be able to have the evaluation completed. And so that's sort of the two big things that the court is looking at between now and then. So I'm going to order a couple things. So I am going to put this matter over. I want to give you both enough time to get that done. Let's see. I'm going to set this case to October 12th. Then one or both of you should have filed the substance use evaluation. Again, you both want to talk about it. So my recommendation is both of you file it. It doesn't hurt me to have it twice in the file. It does hurt my decision-making ability to have it not at all in the file. So one of you please file it. Number two, sir, that gives you enough time to get that anger management evaluation completed and filed. And then lastly, do you two have each other's phone numbers or no? Ma'am, do you have his phone number?
No.
Okay. So do you have his mailing address?
Yes.
Okay. Here's what I'm going to have the two of you do. Is number one, I'm going to order that you both sign up for a program called Our Family Wizard. If you Google Our Family Wizard, you will find it. What it is it's a parent communication app. So there's an app that'll go on your phone and or on your computer, and you can use it to communicate. At some point, the expectation is that he will complete the evaluations. There will be visits at some point in the future. The two of you will need to communicate, and then this creates a sort of safe portal to do that communication through. You're each going to pay your own cost for that service. It's not very much. It's about $10 a month or so. So you're each going to pay your own fee for that. Finally, I'm going to start, let me look at your final parenting plan. Okay, I don't see it. So finally, what I'm going to order is what's called loser pays drug testing. What that means, ma'am, and just as to miss her, what that means is that you, ma'am, can ask for a drug test and you have to prepay for it, meaning if you want it, you have to go to the testing facility and actually put down the money for it. But he then has to take that test. So, sir, obviously there's been an allegation that you have misuse substances, and sounds like there's some evaluations that indicate as much. It's important that you be clean. And so if Mrs. thinks that you're not clean and wants to have you tested, she can do that. You can ask for either a UA or a hair follicle test. They have different price points. So I'm authorizing both. It's up to you, ma'am, to choose what you want to do. If the test is negative, then ma'am, that's sort of, you've paid the cost and test is negative. That's the end of the story. If the test is positive for illegal drugs, then at that point, sir, you owe her a reimbursement for that amount of the test. So you're coming to court, saying I'm not using. If that turns out to not be true based on the testing, then at that point, you're going to need to reimburse her. The way you're going to notify him to take the test is via Our Family Wizard. So you both need to sign up for that. I'm going to give you, today is Thursday. I'm going to give you both until Monday. Oh, actually, I'm going to make that Tuesday because Monday's a holiday. So I'm going to authorize that by Tuesday. So ma'am, you can't ask him prior to Tuesday for a drug test, only because if he hasn't signed up yet, he won't see it. And then, sir, you need to take that drug test within 3 days of her requesting.
Okay.
Okay. Does that make sense to you, ma'am?
Yes, that does.
Okay. Any questions from you, ma'am?
I do. What about his child support arrangements that he's not following through with?
So we're not addressing that today. If there's something that you want to address regarding child support, you have to file a motion and get that before the court today, or get that before the court. So you have to file your motion and then schedule it or docket it before the court. So it's every time your case comes before the court, sometimes people have this feeling like it's just a grab bag and we talk about anything, but really we're just talking about the narrow issues of what's actually been scheduled for us to talk about or for the court to make decisions about. So right now, the only issue really is reviewing these evaluations, which we've done, and I've put a couple more pieces in there, but they're all kind of associated with that same questions. But I appreciate you bringing that up. Any other questions from you, ma'am?
No, I think that, are we going to be looking at reunification counseling as well for this process if we get to that point?
If we get to that point. So we're going to take a look at the evaluations. We like to see those completed and in the court file. Once we have those, and ideally the court will have those when we come back on October 12th. And so if we come back on October 12th and those are all completed, the court will then start looking at probably a reunification evaluation would be kind of the next step. So we'll have some folks that I think they're doing those either at low cost or potentially at no cost. And so they'll do an evaluation on sort of what's needed as far as reunification. Okay. And then, sir, any questions from you?
You said that is called My Family Wizard.
It's Our Family Wizard. So
Our Family.
Like our, as two parents, Our Family Wizard.
Okay, and I can just find that on the App Store?
You can find it on the App Store. So it's on the App Store, and you can also Google it. You'll find it either way. But it is designed to be a phone application that the two of you can then communicate and talk. And then that way, ma'am, you don't have to give him your personal phone number or email. The app itself just sends the communications through like a portal.
Cool.
Okay, other questions? Oh, hold on. Other questions from you, sir?
No, that is it. I also, I planned on just voluntarily giving a hair and nail follicle test because we were at one point seeing another judge. And he had told me that I had to ask for a 12-panel hair and nail follicle test. I was just waiting to afford one. So I was going to give one of those anyways, but if you want to do we can go about it that way too.
Either way, it certainly is helpful for the court to have before the court moves forward. So it provides some assurances that you're clean. So certainly helpful to have if you can afford it.
Okay.
All right. And then, ma'am, I'll turn the time back to you. Any other question?
I guess I just didn't understand how that worked, how it connected us, but I'll figure it out.
Yeah. The app itself you put in everybody's names and it will match you up. So the app will connect the two of you itself internally. So you don't need to know any of his personal information other than sort of like names and simple names, case numbers, things like that. And the app should connect you.
Okay. Thank you.
All right. Thank you both. So we're going to see you back here on October 12th at 9 a.m. Again, please make sure that you have filed all those things. And then, sir, looked like you had one last question.
And, we're going to need to know the case number.
You potentially might need to know the case number. Do you have a piece of paper?
I can just jot it down in my phone real quick. And if that is okay.
Yes, of course. That's correct.
Perfect. Thank you.
All right. Thank you both for being here.
Thank you.
I have the guardian ad litem, Ms. Cole. I have Mr. Alton, and I have Ms. Keith. All right, great. I'm happy to have you all. Thank you to guardian ad litem. In this case, I do see that you got your report in yesterday, and the clerks were Johnny on the spot getting it filed for me, which I appreciate too.
I'm glad. I tried to provide a bench order. I hope it reached you. I mean, a bench copy.
So perfect. It was able to make it to me. I've been able to take a look and review it. So at this point, here's where I am. It's my understanding that DNA testing has been done, and that at this point, it's not disputed between the two parties that Mr. Alton is the parent of the child for this action. Is that your understanding, Ms. Call?
Yes, that is my understanding. I've seen the test, and these two folks have gone in and out of co-parenting very well together, and at other times not as well. Landon acknowledges Mr. Alton as his father. Ms. Keith acknowledges Mr. Alton as his father, as did Mr. Janke, Ms. Keith's former husband. Looks like we may have lost Mr. Alton.
Okay. And all right, then Mr. Janke entered an order of relinquishment in 2019. Was Mr. Janke ever on the birth certificate for the child?
Yeah, he was.
Okay.
I believe a new birth certificate has been established. Am I correct in that statement?
I don't think so. I'm trying to fight with the health department and get on the birth certificate. I've talked to them a couple different times, and then they gave me some numbers to call. And so I am currently in the process of trying to figure that out.
Okay. And I ask because the case just has some odd procedural history. So when Mr. Janke was added to the child's birth certificate in 2017, is that right?
I think it was 2014 or 2013. Oh no, it was 2014. Somewhere in there.
And then this was filed. Okay, and then there's a petition to determine parentage that was filed in 2022.
The one that was filed in 2022 they ended up dismissing that eventually because Brock, myself, and Ashley were all on that case, And since Brock removed himself from the birth certificate and everything, then it kind of I had to change the case to just Ashley and I.
You say that he removed himself from the birth certificate. Was there ever a birth certificate issued for the child that had no father, like an unlisted or unknown father?
When he was first born.
After Mr. Janke was added to the birth certificate, was he ever removed such that the birth certificate just now says no parent?
No, he was supposed to relinquish his rights to Garrett, and then Garrett was supposed to initially adopt him, is the way that they figured it out last time.
Okay. So back in September of last year, the court signed a final order establishing Mr. Alton as a parent. And the only thing the court reserved was the parenting plan, saying that essentially that part had to be reserved, that the parenting plan, child support were reserved, but that otherwise the court granted the order. Okay. So that being the case, at this point, the court has made a year ago an adjudication that Mr. Alton is the child's parent. Sounds like there's some issues. And so I would invite you, sir, to maybe send those orders from September of last year to the Washington State Vital Statistics to see if that will solve the problem with the child being with both of the two of you listed on the birth certificate. But that does resolve sort of that question for me. So thank you for sort of granting me the time here to look through the additional file. Okay. All right. That being the case, so Ms. Call, I did receive your report. Thank you. It's extensive and very helpful because this case is complicated and has, again, some odd procedural history. And so is there anything you'd like me to add regarding, or anything you would like to add regarding the outcome for this young child?
Just that I know it's been a very contentious few months, and that Ms. Keefe has experienced a lot of heartache since June, since this temporary custody issue came up. And I appreciate the way that these two people have, while they still struggle to communicate in certain areas of this case, they both truly have Landon's best interest at heart and are both interested in having loving relationships with him. I think the conflict comes when it's the two of them trying to work out the details of that, how that relationship should operate. And so I think really by leaning into communication being restricted solely to drop-offs and pickups, Landon's well-being, and having that happen within the app, as I wrote in the recommendations there, I think that's the healthiest way for Landon to be able to experience life with both of his parents and to hopefully find some peace and some security and consistency going forward. I think that right now, especially since Landon's starting to begin mental health and starting his 7th grade year of school, I think yesterday was his first day, I believe. Then hopefully this next school year, he can be in school every day as he's needed to be. He can be attending mental health sessions. He can see his doctor on a regular basis and hopefully come to a place of finding some consistency and peace with both of his parents.
Thank you. All right. So with that, sir, I'll turn the time to you first, and then ma'am, I'll turn the time to you next. So sir, since you're sort of the moving party in this action, what would you like me to know about establishing a parenting plan for your child?
I have my camera off. I have really bad service at work. I just wanted to let you know that real quick.
That's okay.
It dropped out once. Okay. So I just have a few concerns. When Ashley or Ms. Keefe was granted visitation for the month of August, she did not follow the plans at all. The plans were 3 days of visitation, and for 3 of the visitations, she had him for 3 nights and 4 days. And I kept telling her that it was just 3 days for visits. And then I even told her not the last visit.
Oh, looks like we lost him. I'm going to wait just a minute. So I know I still have you, ma'am, but it's important that you both hear each other. I'm going to give him a minute to reconnect.
Sorry.
That's okay, sir.
I usually don't have this problem.
Go ahead.
And so, I showed up for the drop off, and Ashley never showed up, and so she said that she was getting ready to work. And Landon's attitude has not really been the same. And he's been lying about stuff going on, and it just feels like, she's trying to get.
Your Honor, I'm sorry to jump in. I wonder if Mr. Alton might have more success on a phone call into Zoom. I wonder
That's
if that's
true. Mr. Alton, you can call in as well, and use like a telephone or a landline to call in if that's available to you. Is that something that you can do?
Yeah, I'm on my cell phone.
Okay. Sometimes even if you call in from a cell phone, it's better.
Do I just call?
So the way that you would call is if you look the same link that you use to get to today. If you click on sort of the correct docket for today, which is the correct court session. If you click on that, there's kind of a further down, if you scroll down a little bit, there's a phone number that you can use to call in. Very good. All right, so sir, I'll turn the time back to you. You had talked about how there was some misunderstandings or problems with the visits in August, and that's kind of where we left off, where you disconnected. So go ahead and start back up there.
Okay. And so Landon's kind of attitude has been changing. He was doing very, very good, and then phone calls were starting to get made to Heather, and accusations were being made to Heather about Landon being left home alone for 10 to 12 hours at a time with no food. And it's just, it's kind of just, it's a cycle. It's been a cycle. This is like the 3rd or 4th time that this happens, and it's just continuing on. And Landon is being told things to get turned against me and not want to come to my house. And instead of getting support and, being mentally stable in life, and it's just very concerning to me still to this point. And that's all I have.
Okay. And so, ma'am, I'll turn the time to you. What would you like me to know?
Can we ask what lies are being told real fast? Can I ask questions to him?
No, this is not a trial. You may not do that. We're not cross-examining anybody.
Okay.
You can just tell me what you would like me to know.
Okay, Landon was supposed to have, I think, 2 or 3 different meetings with Heather, like phone calls, and he never got to do that. I didn't get to see him for 2 months, and he was still trying to make those calls to Heather, so I don't understand how that's my fault, by the way. Also, I've always been okay with him having contact with his dad. Garrett didn't reach out to me for a year to even try to set up any sort of visitation or anything, or even check on him. So I'm not really sure how I'm at fault for that either. I also have gone through my mental eval, and I've gotten registered with counseling, and I can see a psychologist if they choose that I should see one. I'm medicated for my anxiety and my depression. I also got the substance abuse assessment, and I also didn't have to have that. And I passed my UA and a hair follicle test. So I think all of these allegations are just kind of getting old, honestly. I'm completely fine, like, with whatever Landon wants to do. Like, I have no problem with Landon seeing Garrett or being with Garrett or anything. I have a problem with them talking horribly about me in front of him. And I'm sure that's probably why. I guess he got in trouble for seeing my mom, because he has an app on his phone that tracks him. I would rather it go back to like what we had before, because he could hardly maintain those visits to start out with, like, because we did Thursday through Sunday, and then the next week we would do a Wednesday night, and then we split holidays so that he could go when, like, Garrett has 3 sisters, so he could go, like, for those days or those holidays, so they'd have the same holiday schedule and everything. I think that, like, Huntington is probably a bad idea, but, like, if we tried it, it'd be okay. But he really wants to go to Tootle. His friends are all there. His brother goes to Tootle. He went to Tootle before and he did really well there. I honestly don't think Garrett should have any sole decision making in any way. Like, I don't think he should be able to choose the school. Landon doesn't even want to go to a big school. That was the issue. With him going out of Mount solo. Also, I didn't get done with the homeschooling because he got taken from me. So that doesn't really work out.
He was on summer break.
Oh, hold on. No, one at a time. I'll call on you before you need to jump in. Ma'am, where do you live right now? What city?
I live in Castle Rock. But it's the Tootle school. I live in the house that I grew up in, and I grew up and graduated K through 12 at Tootle.
Are you currently living with your parents?
I'm living with my dad right now, but I'm looking for something in the school district.
Okay. And so you say you're living in Castle Rock, but are you living in the Tootle school district?
Yeah.
I was confused. Okay.
It's weird. The school district lines up weird.
Okay. But you anticipate moving and finding your own place.
Yeah, and even if I, like, lived in Kelso or something, I could still bring him to Tootle, to my dad's house. I've done that before too.
Are you currently employed?
Yeah, I'm a CNA for Americana.
Okay. How much do you make per hour?
Right now I'm making 21, but once my CNA license gets finished, which should be soon, I'll make almost 27.
And then, sir, what city do you reside in?
Longview.
Okay. And where are you employed?
For Adams Timber Service.
And are you hourly or salary there?
Hourly.
Okay. How much do you make? Do you know how much you make per month?
I think right around 6,000.
Okay. Okay. All right. Right. Before we move on, anything else you want to tell me, ma'am?
Honestly, I think we're better at communicating without the Wizard app, first off. Once we're, like, in, like, agreements with stuff and everything, we can usually talk our way out of stuff. And I think that, like, for, like, our changes and stuff, like, I think Landon's old enough to have, like, probably a sit down with me, Landon, and Garrett can, like, figure our stuff out, like, and have him, like, be a part of, like, changes and stuff. Like the school district and stuff like that.
Okay.
Or sports,
and then,
or anything.
Do you drive?
Me?
Yes.
Yes.
Okay. I asked, some people don't. So that's why I asked.
Okay. I was like, yes.
And then what's your work schedule?
Right now it's 4 on and 2 off, and I work 10 p.m. to 6 a.m. I actually, when I got visitation back with Landon, I missed a couple days because he was freaking out when I was doing the 3 nights, because I would get him my 2 nights off, and then one of the nights I was working. And so I had to call in 2 weeks for that because he was having a meltdown about me leaving him. But now I can bring him to work with me, and he can sleep in one of the empty rooms if we have to do it that way.
Okay.
Your Honor.
Yes, ma'am. I'll turn to you.
Okay. Yeah.
Go ahead. Ms. Call.
I'm sorry to interject. I just want to inform Ms. Keefe and Your Honor that Tootle Lake District is its own district, and that Castle Rock District is different. Tootle Middle School is not in Castle Rock District. That's not accurate.
That was my understanding.
I graduated from Tootle, and I grew up in this house. The school bus goes by this house.
It's possible that the district lines have changed. I'm just looking at what's listed.
No, it's been like that.
I'm not trying to start a dispute.
Yeah. All right, that's fine.
Well, I'm just saying
that doesn't give me any heartburn with my decision, frankly.
Okay.
Hold on, I'm just making a note. All right, so sir, so I always give you an extra opportunity to speak, in that Ms. Keefe got to hear what you had to say before she spoke. And so now you've heard her speak. Yeah, so I'm going to give you an extra opportunity to speak, and then Ms. Call, I'll touch base with you before I make a decision as well. So, sirs, after having heard Ms. Keefe speak, is there anything that you would like me to know, kind of specifically around what she spoke about?
Yeah, she's been talking about finding her own house, but Landon was informing me that she is currently looking for her house with her new boyfriend, Chucky, that I believe they've been recently started dating now, and maybe within the last month, and she's looking to move into a house with somebody that not really, I don't think Landon knows or anything. And for the school thing, he was enrolled in Huntington because his counselor is also his counselor at school is also his main counselor at Columbia Wellness. And so Landon and I talked, and it makes him much more comfortable having an adult that he can fall back to and have that security at the school with him. And his biggest thing is, I have been to parent-teacher conferences, and everyone said he does great when he's at school. His biggest thing has been attendance issues. And I get up at 3:30 in the morning for work and get home at 6 o'clock at night or later. With him going to Toodle, that would make it super stressful on myself and everybody around to try to run him 30 minutes back and forth. And, Ashley works nights, so she could easily take him to school after, or pick him up from school after she goes home and sleeps. That way I am ensuring that he's making it to school every day, because the attendance issue just wasn't last year. I have a transcript from Toodle Lake when he attended Toodle Lake that he had missed over a month of school there as well. So this thing has been year in and year out. It's not just, starting recently. And, it's just, he has his counselor there. He went to Mount Solo. I talked to the principal at Mount Solo. He was never bullied. He never approached an adult teacher, talking about the school being too big or not making friends or anything. I feel that he struggled to make friends and be social because he was just never there and could never build relationships with anybody while he was attending.
All right. Thank you, sir. I appreciate that. And then Ms. Cole, I'll give you the last word.
I feel like I've made the points I needed to make. The last thing I did want to address is concern around Ms. Keefe having vehicle insurance. When I interviewed her, she did not have insurance for her vehicle. This is something I wish I had included in my recommendation. I want to make sure that she actually does, in fact, have a valid driver's license and has insurance before we know that she's transporting Landon long distances. That's my last sort of concern, is that she's insured and has a valid driver's license for him to be in a vehicle with her.
All right. Thank you both.
Thank
you all.
Do I get to go?
No, ma'am, you don't. So it's just sort of how the system's arranged. The moving party speaks. You get to hear them speak before you speak. So he didn't get to hear sort of what you had to say. Then that's why I give him a brief rebuttal at the end. And then I do like the bookend with the GALs, since they're sort of a neutral party to this. All right. Number one, to both of you, Landon is he 11 or 12 now? How old is he?
He's now 12.
Well,
I'm sorry, Ms. Call, go ahead.
He's 12.
He's 12. Okay, that's what I had in my mind, was 11 or 12. All right. Folks, 12-year-olds are not adults. They're not. And especially, we have a young man who's been pulled around and had kind of some rough things happen to him as a young person. To be told, this is your parent. No, it's not your parent. Now that person who's been dismissed from your life for several years is your parent. To have frankly, people who absolutely were this child's parent in his eyes drop out of his life completely. That's very, very hard for a young person. Frankly, I can't imagine doing that, even if that child was not biologically your child, to just say, done with you. So this young man suffered a lot of hurt these last couple of years and suffered quite a bit. We've had a lot of upheaval in his household. Ms. Keefe, you don't really deny, and I don't think you could, sort of, there's been a lot of changes in your life too, that your life has been pretty difficult. Kids suffer because they come along. And as much as we try to shield them and shelter them from some of those hard things, there's some practical realities that kids are aware of. But I invite you both to recognize he is a child. Number one, do not ask him to make decisions. Do not involve him in adult conversations. And what I mean by that is, Ms. Keefe, you're like, well, we can just sit down and have a conversation. No, he's 12. He doesn't make those decisions. It's not fair to him to make those decisions. You are the adults. You are the ones who need to make the decision. And then you tell him the decision that was made. You can talk to him about his input, but he doesn't make those decisions. The two of you need to make them and not put him in the middle. Number two, both of you need to leave him out of litigation or court stuff. Don't talk to him about court cases. It's fine for you to explain the schedule to him, like, hey, here's the schedule, but I invite you both to make it positive, that this is the schedule, this is going to be great, regardless of how you feel about it. And that's to both of you. But leave him completely out of the court process. Don't encourage, at this point, the guardian ad litem has completed her report. Her responsibility to both of you is concluded. So sort of, I think people tend to kind of amp up, and increase their rhetoric as cases go forward. That's kind of over now because the guardian ad litem's done and the report is in, and I'm going to issue a temporary order today. So this idea that you're going to try to get the kid to say this or get the kid to say that, don't. A, that ship has sailed. And B, when you do that, it alienates the child from you. Ultimately, you are asking that child to lie if the things are not true. And ultimately, that will backfire on you because you have a young man that is very shortly going to be a teenager. And when you teach a child to lie to someone else, you're teaching them to lie to you. And that is the hard, cold reality. You want your child to be honest with you, to know that you are a safe place to both of you, a safe place that he can come and tell you what's going on. I will note, and I do find that this young man suffered educational neglect. Withdrawing him from classes with no executable plan is unacceptable. You can't say, well, we planned to homeschool, but then you didn't. Before you ever took him from classes, if you were going to homeschool, that should have been ready the very next day. We'll get to it when we get to it. Because now he's suffered losses educationally. He's going to have to work real hard these next couple of years to get back. And especially in light of young people having gone through COVID this last couple of years, educationally, kids are already stressed. So to put extra stress on that young person is unfair to him. So I do find that. So a couple things for both of you. Number one, the guardian ad litem has asked for some assessments. I'm going to leave those out of my order for now. On a temporary basis. Both of you are encouraged to complete them. I'm not ordering them at this time. What I am ordering is that both of you complete a parenting class called Love and Logic. This is not you're a bad parent class. This is a class where both of you can attend, and then you both have a base idea of a certain parenting style, so that ideally when the child's in both of your homes, you have similar tactics on how you manage them. It's a class that was originally developed for teachers and was so effective, they developed a sort of subset of it for parents. And I like to order it because I think it gives you both some base understandings on how to be the best parents you can be. And I think this kid deserves that. Number two, you're both going to complete a parenting class called Children in Between. It's only about 4 hours. It's how to be good co-parents. It's specific training on how to be a co-parent, frankly, and how to not put your child in the middle. So I'm ordering both of you to do that. I am going to order that you continue to use Our Family Wizard. I think that's reasonable, at least at this time. This is a temporary order. It's not a final order, but sounds like you're already using it. I want that to continue. Child needs to continue with his mental health counseling. That's appropriate. Sounds like that's getting on board or has gotten on board. That needs to continue. I am ordering what I'll call loser pays drug testing for you both. You both have some substance abuse history and I'll call it question marks. And so what I'm ordering is that either of you can ask through our family wizard that the other parent be drug tested. Or that's generally going to be through a hair follicle or a UA. If you're asking for the drug testing, you have to pay for it up front. If it's negative, then or not in violation of this court order, then sort of you just eat that cost. If it is in violation of the court order, then the other person has to reimburse you. So you have to pay up front, sort of kind of put your money where your mouth is. But if the other person's dirty or in violation of the order, then there's an obligation to pay you back. Neither of you are to drink alcohol or use marijuana during your parenting time. Means that if the child's with the other parent and you want to go out with some friends and have a good time, go for it. If child's with you, that is not an option for you. Period. End of story. Don't cheat. Don't do something in between. For now, this is the order. Both of you are sort of on notice as to that fact. If you use marijuana for many of its purposes, figure out something else, at least during your parenting time. All right. So getting into the child's actual schedule. Hold on, let me make sure I do appreciate the Guardian 11 gave me a lot of information. All right. So as to child, child's going to reside primarily with the father. I think the father is more stable and this child needs and deserves some stability. Mother is going to have a visitation with the child on every second and fourth weekend of the month. And the way you determine the weekend is going to be determined by Fridays. Mother's weekends with the child so I struggle with this. I'm going to make them a long weekend and it's going to be Thursday to Monday morning drop off. So her obligation is to pick the child up from school on Thursdays. You will drop him off back to school on Monday. If it's a 3-day weekend, you drop off back to school on Tuesday morning. The idea is this keeps the two of you separate, so you don't interact at 99.9% of the exchanges. It also connects Mrs. to school and make sure that she's picking up those times where teachers will just snag you and say, hey, this is going on. That way mom has some buy-in for that too, and some responsibility. I am adopting though, the guardian ad litem's recommendation that, ma'am, if you don't get him to school, so you're gonna have to get him to school on time without misses on Fridays and on Mondays or Tuesdays if it's a holiday. If you miss more than, I'm adopting the guardian ad litem's recommendation. Maybe it's on the next page. More than 2 unexcused absences from school in a semester, then the father can come back to reduce your time. So essentially, you get 2 misses every half year. So basically every 6 months. The easiest way to break it down is, September to December, you have 2 misses where he could be late or have an absence. If he's sick, you better take him to the doctor and get a note. Kid has to be to school. He's got to be on time. That has to be a priority for this young man. He's got to get back on track. Education.
We know that Garrett also was involved in his latenesses.
No, I'm ruling. Okay. So that's when you're not talking. I'll give an opportunity to everybody to ask questions. But at this point, you can ask questions when I'm done, but I'm done taking information. And again, this is a temporary order. It is not a final order. I am going to do standard holidays. That means I'm going to get an equal sharing of holidays to both of you. And I'm going to write up a parenting plan for you just so that you have it and it's done. That'll be entered by the end of the day and you'll both be able to get a copy from the clerk's office tomorrow. And I invite you to come do that so that you can both have a copy of it. So standard holidays, visits. If either of you lose your housing, you need to notify the other parents. I'm not going to make an order on what happens, but if either of you lose your housing, you need to notify the other parent within 24 hours. It's not reasonable that the child be in that situation. Over the summer, you're each to have the regular parenting schedule will continue through the summer, but in addition, you can both have an additional 1 week. You can tack that 1 week to your regular time. So that means, ma'am, for you, you can take your regular weekend, long weekend, and then tack an additional 7 days. So your weekend ends normally on a Monday at 9. If you wanted to then tack your vacation would go to the following Monday at 9 a.m. So that's what tacking means, is you can sort of butt them up next to each other time-wise. Ma'am, you're to continue in your counseling and to continue with all medications that are prescribed to you. That's appropriate. I'll give you each half of spring break because I think that's reasonable for you both. And then, ma'am, because you have an unusual work schedule, it's not reasonable to take your child to work with you. That is not a reasonable thing for a 12-year-old to do. And so, especially given the work that you do. So if you are working during your parenting time, and it sounds like you're generally working the night shift or, the overnight hours, then you have to let my client know, and he has the first option to care for the child. And that will be from 8 p.m. to 9 a.m. So essentially, while you're working, kid goes to dad to sleep, have dinner, go to sleep, wake up, but then you can have him back. So essentially,
I'm asleep before 9. I get off at 6 a.m.
Then I understand that. I'm not waking a child up at 6 a.m. to transfer him back to you. That's not fair to him. So that's something you're going to have to figure out.
He gets up at 6 a.m. with Garrett every day.
Nope.
Okay.
You can use a transportation designee if you would like. You can do that. But again,
can he stay with my dad, who I live with?
If your dad is a safe and reasonable person, then he can pick up the child. That's fine by me.
No, I mean, can he stay here at our house and stay with my dad, so I don't have to meet Garrett every time I work?
No, the father has the first right of refusal. So that means that parents have priority first. Because again, I want parents to have priority over all other people. All right. And so child's going to attend school in the father's school district. That's reasonable for this young man. At this point, I don't believe there's a current. I'm not making any orders as far as child support. I don't have sufficient information to feel confident about that. Either of you can raise that issue at a later time. I believe that resolves all of the parenting plan at this time. So with that, Ms. Call, any questions?
No, Your Honor, I appreciate what you've created there.
All right, sir, any questions that you have about the order that I've made?
Yeah, I was just confused on the drop off and pickup. So on the weekends that she's gonna. So do I take Landon to school on Thursday?
So
I was kind of confused on that.
That's a great question. Thank you for clarifying. So what you're going to do is you're going to drop off to school on Thursday mornings. So child would have slept at your home Wednesday night to Thursday morning. You drop off to school on Thursday. Mom's going to pick up from school at the end of the school day.
Okay, and then she'll drop him off on Monday, and I will pick him up on Monday.
That's correct.
Correct.
She'll have to be responsible to drop him off and pick him up on Friday as well.
Okay.
Good. Other questions, sir?
That's it. Sorry.
Okay. Ms. Keith, any questions you have about the court's order?
I was supposed to get him today, so do I not get him today?
Let's see, today is Thursday. Let me look at a calendar real fast. So I'm going to have him stay with dad because I'm awarding you the second and fourth weekends, and this upcoming weekend, September 1, is the first weekend. So you would have next weekend would be your time would start next Thursday. September 7th would be your weekend. Okay, other questions?
Nope, that's it.
Okay, so what I'm going to do is I'm going to draft a parenting plan and enter that order for both of you. Again, you'll have to come to the courthouse to get a copy of it. Bring some cash because they do charge for copies, but you will both want to have a copy of the plan in black and white so you both know your responsibilities. And then that way everybody knows for sure sort of what's what as far as the court order goes. And then everyone needs to follow that court order. One last thing, folks, this is a temporary order. It is not a final order. Because it is not a final order, your case is not done. You still need to either A, reach an agreement on your case, or B, take your case to trial if the two of you can't agree and resolve it at trial. So those are sort of the two ways off this freeway that is your case. So please be aware of that. If you don't complete your case, at some point the clerk will just dismiss it. So it behooves you both to move it forward and get it completed. And then Ms. Call,
Okay.
Anything further?
I'm just curious about my motion for discharge, if that was going to go through today.
It is. Thank you for raising that. Yes. So just so both of you folks know, Ms. Call is requested to be discharged. That just means that the court asked her to do an investigation and write a report, and she has done that. And so there isn't anything further for her to do because she's completed everything the court asked for. So with that, I am going to sign that order. And so again, I appreciate you, Ms. Call. I appreciate both mom and dad. I know you both love this young man very, very much. You want the best for him. Go from this hearing. Neither of you got everything you wanted. You both now have some things you've got to go do. Go from this hearing with sort of your eyes on the prize. And that is eyes on your son to have the best life he can have. The most productive life he can have, be supportive of each other as parents, because again, he's 12, he's going to be 13 in a hot minute, and it'll take both of you to bring him all the way through graduation day. So both stay involved, both continue to do all the right things, and ensure he has the best outcome, because he's the priority. Although both of you are important, he's the priority, and I think you both understand that. So I appreciate both of you. Both of all of your efforts so far. Just continue with that thought process. All right. Thank you both. Again, you can get a copy of that order. I see you there, Ms. Dow. Wonderful. I have looks like the petitioner, Ms. West, present, represented by Ms. Dow. And let's see. Do I have? And I guess I'll turn the time to you, Ms. Dow. Has either parent been served?
Yes, Your Honor. Ms. Melton was served on the 28th, personal service. We did send as a bench copy the confirmation of service, but it was just sent to the docket, so it may not have gotten to you. And I believe she is here present. That would be Marlene Melton.
Okay. And what about service on Justice Jonathan Anderson?
Mr. Anderson is deceased. He is
Okay.
Ms. West's son and the father of the child.
Thank you. I do see that in the file now. Thank you. All right. Thank you for that. So I'm going to turn to you, Ms. Melton. I do see you there and present. And if you go ahead and unmute yourself. All right. So did you receive copies of the paperwork in this matter?
I did, yes.
Okay. Very good. Obviously, you were just served those very, very recently. I don't see that you have filed anything into the court file. Did you file anything for today?
I gave a bench copy, Your Honor. That should have made its way to you, hopefully. I did not have adequate time to file paperwork.
And Your Honor, we did not, we were not copied in on that bench copy as far as I know.
Okay. Looks like I received some materials, but I'm a little nervous that I have some originals. All right. So here's, it's really important, Ms. Melton, that A, you have sufficient time to respond, and that B, Ms. Dow is afforded a copy of anything that you file. So whenever we file things into the court record, there's sort of no secrets. Everything is sort of out in the open for everyone to see. So anything Ms. Dow files, she's going to be required by law to send you a copy. But anything you file, you also have to send her a copy. so that way everybody can see everything in the court file. And I'll assure you that Ms. Dow will do that and send you copies. I'll need you to sort of have that same obligation and send her copies of everything you file. Ms. Melton, are you planning to hire an attorney?
I am looking for one. Yes, I'm looking for one that I can afford.
Okay. Are you currently working?
Yes, Your Honor, I am.
And how much do you make per hour?
Per hour, I make $21 an hour.
How many people are in your household?
3.
Okay. Who's in your household?
Donovan Anderson, myself, and then my spouse, Philip Shane Ireton.
Okay. And does that person work?
Yes.
Okay. I'm just sort of doing a very rough evaluation to determine if the court can appoint you counsel. Do you work full-time, ma'am?
Yes.
Okay. So based on sort of your income and your significant other's income for a family of 3, it doesn't look like that would sort of qualify for court-appointed counsel, at least at this time. If your financial situation changes or you want to file something about that, you're free to do that. And you said that your significant other, he's working. Do you know how much he makes per hour?
$26.35, I believe, Your Honor.
Okay. A couple things that we're going to do today. So for the purposes of today, I want you to have ideally an opportunity to find counsel, if you can do that, and submit your materials. You're free to submit additional materials, but anything that you submit, you have to send a copy to Ms. Dow. But because she hasn't had an opportunity to look at your materials, the current order that's in place is going to remain in place for the moment. I'm going to ask you, Ms. Melton, though, so I can set the matter over just a single week, but that doesn't give you a whole lot of time to be able to find counsel. Would you like to go over more than 1 week or stick with a week?
2 weeks, if I could, please.
2 weeks. Okay. Ms. Dow, does 2 weeks work for you?
Would that put it September 14th?
It would.
Yes.
Okay, very good. So what I'm going to do is I'm going to set the matter over to September 14th. Again, that gives ideally you time as Melton to find an attorney and get materials filed. You can make sure your attorney gets a copy of anything that's been filed already, just because that'll speed up the process of getting Ms. Dow served. And your attorney, if you hire one, will take care of getting Ms. Dow served with copies of any materials. I am going to maintain the current temporary order that was issued, and then we'll just set that new date for the 14th. Is Donovan current? So before I sort of turn the page on this case, Ms. Dow, is Donovan currently attending school?
Yes, Your Honor. Ms. West, because there was no indication of arrangements for him to attend school, Ms. West has started him in his school that he attended last year. Also, I would like to just note, and Ms. West can correct me if I'm wrong, but I believe the child is scheduled for sort of immediately necessary surgery on the 14th. Ms. West, is that correct? You're muted.
Yes, it is.
Can you still?
What surgery? What is the surgery?
It's to remove polyps on his throat.
Okay. Okay. I know, sir. I know you don't always have the answers to this question. So, is there a specific time?
I don't have the time yet. Typically, they've been really early. It started, probably be there about 6 in the morning, and it's usually about an hour and a half, 2-hour surgery. And then we're usually home by 1 p.m. usually, but.
Okay. So that being my understanding, I don't really want to set all of you up for a hearing on the 14th if the child's in surgery on the 14th. That sounds like a bad plan for everyone involved. Ms. Dow, are you available on the 21st?
In the morning, yes.
All right. Ms. Melton, are you available on the 21st?
Yes.
Okay. Let's do the 21st. Child surgery should certainly take priority and certainly take everyone's sort of attention priority that day. So child should continue with all surgical appointments and consults pre-surgery. That's very important that continue. Just one moment. So that's going to be my order. That again, child to the school that he's been enrolled in and likely has had his first day in already. We're going to maintain that. Nobody's going to disrupt that. Similarly, medical appointments are to be made. That's more than appropriate. And then Ms. West, do you have Ms. Melton's contact information, like a phone number or something of that nature?
Yeah, I do have a phone number.
Okay. I'm going to ask. Go ahead.
Excuse me, if I may, it would be helpful if Ms. Melton would provide us with at least a mailing address where we can exchange legal documents, or I can text her or call her and get an email address. Both would be preferable, just so that we could be in communication and so that Ms. West and the child can be in better communication with Ms. Melton.
So Ms. Melton, do you have an address where you want to receive legal paperwork? It doesn't mean that you have to live there. It just has to be a good address that can receive that paperwork and then make sure that you get it.
I can give my home address. Yeah.
Okay. And are you comfortable just doing that online with us today?
Of course.
Okay. Ms. Melton, if you are okay with this, I will send you a text message to your telephone number, and maybe we can exchange email addresses as well. That speeds things up for exchange of documents, if you agree.
Of course.
Okay, we can take care of that, Your Honor.
Oh, thank you very much. I appreciate that. And then finally, since it sounds like the current custodian has the ability to text Ms. Melton, I'm going to ask that you text at least at a minimum updates regarding the child surgery. So just the fact that surgery occurred or is occurring, and then I'm sure it'll have a positive outcome, but just that, child successfully went through surgery and is doing well.
Absolutely, Your Honor.
Certainly.
Perfect. Ms. Dow, I'm going to have you go ahead and prepare an order extending the current ex parte order that you entered, and then that will set the date for September 21st as the new date. It'll all still be via Zoom, Ms. Melton. So the same way that you got to court today via the Zoom links is the same way you'll get to court on the 21st. That also gives you a little bit more time, ideally, to find counsel. All right. Anything further from you, Ms. Dow?
No, and we'll have that order to the court today.
Okay, very good. Anything further from you, Ms. Melton?
No, thank you.
All right. Thank you both. Appreciate everyone's time in this matter, and appreciate everyone being here and getting on today. So with that, that'll close today's hearing for you folks. You can go ahead and sign off. We'll see you back here on the 21st. Best of luck and hopefully quick healing to that young man.
Thank you, Your Honor.
We were previously before the court not long ago. So it's like we were previously on the court on August 24th. We extended to today. I've got Mr. Anagnostou. Do not have Mr. Anagnostou.
I believe he's in trial, Your Honor. This is Don Esau.
Were we expecting him to appear through someone else?
Well, he contacted me, I presume Mr. Sosowski as well, regarding a continuance of 1 week. I agreed to that. And he said he was going to be here. He was going to try and escape from the trial at about 10:30 so he could be here. But as you can see, he's not here. Maybe Mr. Sosowski has more information.
I'll turn the time to you, Mr. Is it Sosowski?
Thank you, Your Honor. It's Sasaki.
Sosowski.
And right, no, I did not receive word from your colleague, Mr. Isao. However, I was actually going to request a continuance without prejudice. I just got appointed yesterday, and we've reached out to our client, Michael, and I haven't been able to get a hold of him. So I'm still working on getting up to speed on that. 1 week I think might work, but optimally, in order to, since we haven't had luck contacting the client yet, 2 weeks might be preferable.
Any objection to 2 weeks, Mr. Esau?
Well, Your Honor, my client is also present before the court under the name Georgia. Georgia Wooldridge. She's the mother. She's anxious to get a ruling on the emergency guardianship show cause hearing, which is what we're delaying, of course. And so I'm not sure that she would agree with that at this time, because we'd like to get that ruling next week, if at all possible. So if it's going to go away, she can get the child picked up and moved back to Illinois and into school. So I think that's what her position would be.
Okay. All right. Appreciate everyone being here today. The court's priority is always the child, and certainly highest priority is the child. Second highest priority is parents have constitutional rights to their children that are very important, and I do recognize those. I also recognize practicalities, and Mr. Sosowski is just getting on board. That does take time. It does take time to communicate with parents and then get things in front of the court and also into everyone else's hands so that everyone can be on the same page as far as the materials that were filed and able to review. I'd hate to essentially require everybody to be here next week only to be met with, well, I haven't read that yet. I haven't had a chance to respond to that yet. Because often all parties then, when things get filed, want to respond and file things of their own and have those into the court's hands as well. So with this matter, what I'm going to do is I'm going to set the matter over 2 weeks to the 14th. That'll be at this same docket, the same time. The way you got to court today via the Zoom links is the same way that you'll get to court on the 14th. And so I will enter an order extending the immediate guardianship. Mr. Esau, I would ask that you reach out to Mr. Edegnastu. He's already done one of those, so I would ask that he just refresh it such that it reflects over to September 14th. If you folks would all cooperate and sign off on that order when presented, then it can just be sent ex parte to the court. That's probably the most efficient procedure since there's not a whole lot of changes to that order other than the date from the last order. Mr. Sosowski, do you have access to Odyssey that you've able to get a copy of the court file?
I do.
Okay.
And yeah, I reviewed all the pleadings. And if I may add or ask, I do see that my client, Mr. Michael Erickson, is on the Zoom here, and I haven't had a chance to check with him to see if the 14th would work with him. If he's able to comment, would we be able to check with him to see if the 14th would work for him as well?
Mr. Erickson, if you can unmute.
Yes, the 14th is fine.
All right, very good. Mr. Sosowski, you are my last case. Would you like a breakout room with Mr. Erickson?
That'd be great if Mr. Erickson is okay with that.
Sure.
Okay, just one moment.
I'll contact Mr. Edegnastu and let him know what happened today.
Thank you, Mr. Esau. I appreciate it.
Thank you. All right. Anything further, Your Honor?
No, nothing further in this matter.
Okay.
Thank you.
Thank you.
Myself then. Thank you.